The next point, we should ensure whatever we see is clear.
That means work is being done, we can see that it is in opposite direction.
Hello, learners and viewers at home. Welcome to another segment of e-learning organized by Kaduna State Ministry of Education. Today, we shall be looking at sales of goods under the subject commands. Sales of goods under the subject commands. I still remain my humble self, Yari Zakaria, your commands teacher. In our previous lessons so far, we treated business law. And under business law, I said there are branches of commercial law in which we have treated two. One, law of contract. Two, law of agency. Today, we shall be looking at another branch of commercial law known as sales of goods. Sales of goods. Now, in our previous lesson, we defined business law as law that regulates the operations of commercial activities. Business law are laws that regulate or promote business activities. And such laws include, one, as I said earlier, law of contract. The second one is law of agency. And today, we shall be looking at the third one, Sales of Goods Act. Sales of Goods Act. In this lesson, we shall consider the following, or we shall be looking at the following items. One, definition of sales of goods. Two, meaning of sale and agreement to sell. The third one is terms of contract of sale. And the fourth one is provisions of the Sale of Goods Act 1983. Now, we shall look at the first item, that is the meaning or the definition of sales of goods. By definition, the Sale of Goods Act of 1893 defines sales of goods as a contract whereby the seller transfers or agrees to transfer the ownership of goods to buyer for money consideration called price. The sale of goods is governed by the law of contract. Learners, as I earlier said, that sales of goods, it is part of business law. It is part of business law because there are regulations that guides the process in the aspect of transferring the title of the ownership of goods to the second party. Remember, there are two parties that are involved in the transfer of the ownership of goods. One, we have the seller. Two, we have the buyer. The seller is known as transferor or the vendor. Well, the buyer is known as transferee or the vendee. That is the agreement of the transfer of the ownership of goods by the seller to the buyer is what we call it sales of goods. It is what we call it sales of goods, and it is often governed by what? By a law. A law must regulate it in order to eliminate dispute or disagreements in the process. Parties involved in sales of goods, as I earlier said, are the owners of goods being sold, known as transferor or the vendor, and the buyer of the goods called the transferee or the vendee. Now, we are going to look at the meaning of sales. We are going to look at the meaning of sale and agreement to sell. Meaning of sales and agreement to sell under the sales of goods. Sales occur when goods are being transferred to the buyer at a particular time. Sales occur when goods are being transferred to the buyer at a particular time. Remember, there's what we call it agreement to sell. Agreement to sell occur when goods are being transferred to the buyer at future time. When goods are being transferred to the buyer at future time or future date, it is what we call it agreement to sell. At that very material time, the two parties only agreed to transfer the title of the ownership of goods to the buyer at due time, not at that very material time. In that regard, it is known as agreement to sell, not sales as per se. Now, we are going to look at times of contract of sale. Times of contract of sale. The following times are associated to contract of sale. The following times are associated to contract of sale. 1. Price. 1. Price. 2. The subject matter. 2. The subject matter. 3. Conditions. 3. Conditions. The fourth one is the warranties. Fourth one is the warranties. Learners and viewers at home, we are going to look at these terms or concept or basis one after the other. The first one is the price. Price is the monetary value of goods and services established during transactions. The monetary value of goods and services established during transaction, it is what we call it price. In other words, price is the amount of money expected or given in payment for good. The amount of money expected or given for payment for good is what we call it price. The provisions of the contract of sale state that the price in a contract may be determined by the contract or be fixed by the parties to sales in an agreed manner. So it is price that actually determines the value of the good. It is the price that actually determines the value of the product. And under the contract of sales, that is, the buyer and the seller must agree in such a manner that they must reach a consensus on how to transfer the ownership of goods to one another. Now, the second terms of sale is what we call it the subject matter. The subject matter. Learners, when we are talking about the subject matter in contract of sale, the subject matter is goods. The subject matter is the goods or the product. So under the law of contract sales of goods, the subject matter we are actually talking about what? The goods or the product that is involved in the transaction. In other words, the subject matter of the contract of sale of goods is the ownership of goods bought. The ownership of goods bought refers to as the subject matter. When the title of the good has been transferred to the buyer by the seller. Now, the good that is being transferred, it's what we call it what? The subject matter. There is no how that the buyer and the seller will come into an agreement without the subject matter. And that is why I said it is what? The fundamental basics of the sales of goods. The seller is entitled to sue for the price immediately. The ownership of goods passes to the buyer. The seller is entitled to sue for the price when the seller transfer the ownership of goods to the buyer, and when the buyer fails to pay for the price of such goods, the seller can sue the buyer immediately. The third one is conditions. The third one is conditions. Condition is a requirement or event that should be performed before the completion of another action. Condition is a requirement or event that should be performed before the completion of another action. In a contract, any stipulation which goes to the root of the contract is called condition. The breach of condition gives the other party a right to consider the contract as repudiated or rejected. In the sense of goods contract, a buyer may reject the good because of the breach of condition. Now, when we are talking about the condition, learners and viewers at home, at the point of buying a particular article or at the point of buying a particular product, it is your right for you to ask the seller to tell you the conditions of the product. That is, the state of being of that very particular product. So that process is what we call it the condition. He must tell you the function, the uses, the importance of the product. And as I earlier said, that any breach, by breach here, it simply means when the seller refuse to disclose the necessary conditions being attached to the product. You as a buyer, you have a right to sue this seller because there is what we call it breach of condition. Breach of condition. The fourth one is warranties. Learners and viewers at home, you will bear me witness that whenever you want to buy items in the market, let me use electronics as a case study. When you want to buy electronics in the market, there are some circumstances whereby the seller will tell you that I am selling this item to you and you will continue to use it for the period of this time. If there is any fault or if there is anything that is wrong with the item, you can bring the item to me. I will either what? Replace it or repair it for you. Such is what we call it warranties. Therefore, by warranties, warranty is a written guarantee issued to the purchaser of goods by its manufacturer, promising to repair or replace it if necessary within a specified period of time. In other words, a warranty is an assurance. It's an assurance given by the seller to the buyer about the state of the product, that the prescribed facts are genuine. When you are buying an item, there are tendencies whereby the seller will give you the assurance for how long you will continue to use such a particular product, or for how long such a product will continue to serve you without any problem. And in the case when the product develops any problem, you have a right to take it back to the seller to either repair it or to replace it for you. That condition, that times, it is what we call it warranties. It is what we call it warranties. Therefore, any stipulation which is not of such importance as to go to the root of the contract is the warranty. The breach of a warranty gives the other party a right to claim for damages, but not to reject or to repudiate the contract. In the sales of good contract, the buyer has no right to reject the good because of breach of warranty. Remember, under the breach of condition, you have a right to sue the seller under the breach of condition. Why? Because the seller failed to disclose the state of being of that product to you at that material time. For in that case, if there is any breach of condition, you can sue the seller. But in the case of a warranty, if there is any breach, you cannot sue the seller. You can only claim for your word for damages. Now, after looking at the times of sales, we are going to look at the provisions of Sales of Goods Act. Sales of Goods Act 1893. The following provisions are made by the Sales of Goods Act 1893 regarding the duties of a seller. This includes 1. Right to sell. 1. Right to sell. 2. Enjoyment of quiet possession by the buyer. Enjoyment of quiet possession by the buyer. 3. Good must correspond with the description. 3. Good must correspond with the description. The fourth one is bulk must correspond with samples. Bulk must correspond with sample. The fifth one is merchantable quality of good. The fifth one is merchantable quality of goods. The sixth one is fitness for purpose. The sixth one is fitness for purpose. Then the last but not the least, that is the seventh one, is delivery and acceptance. Delivery and acceptance. Learners, we are going to look at these provisions one after the other. One, right to sell. This implies that the seller has a right to pass a good title to the buyer. Right to sell. It is a law which says that if you are in a possession of an item, you have a right to transfer the ownership to the next party. You have a right to transfer the title of such good to the next party. It is an implied condition that he must have a right to sell good. It is an implied condition that he must have a right to sell good. Learners and viewers at home, you cannot transfer the title of good that does not belong to you. You cannot carry somebody's property and sell to someone without his consent. You must be in possession of that good. When you do that, there is what we call it a breach of contract. Remember, it is an agreement. There is a breach of contract. Let us look at this very particular example. In the case of Akoshele versus Ogidan, 1950, the defendant sold a car to the plaintiff. The car was a stolen one, and the police took it away from the plaintiff. In this case, he does not own the car. He stole the car and he sold the car to the buyer. It means he does not possess this very particular provision, right to sell. The plaintiff received the price, he paid. The court held that the defendant has no right to sell the car. Why? Because the car was a stolen one. Why? Because the car was a stolen one. Therefore, he does not have a right to transfer the title of the ownership to the buyer. The second provision is enjoyment of quiet possession by the buyer. Enjoyment of quiet possession by the buyer. The buyer must enjoy a quiet possession of good without any third-party trade. A buyer must enjoy the possession of what he has bought from the seller without any trade. It is indeed a provision. It is a law that is guiding it. Whenever you bought something from someone, as a buyer, you have a right to enjoy such goods without any trade by the third party. The third provision here is goods must correspond with description. Goods must correspond with description. This implies that where goods are sold by description, the good must agree or correspond with description. Whenever goods are being sold by description, the good that was sold by description must go a long way with what? With the sample. Good must correspond with the description. Like in the case of advertisements, whenever goods are being advertised, what you should expect when buying the good is what you have heard during the advertisement. So whatever you are buying must go a long way with the descriptions of the good given to you by who? By the seller. Let us look at this very example. Attached to good must correspond with description. In the case of Remo and Co. versus Lauda, 1921, there was a contract to purchase 3,000 tins of canned fruit to be packaged in cases, each containing 30 things. In that case, it was held that the buyer could reject the whole consignment as it did not correspond with the descriptions of the good ordered. What we are actually saying here is that whenever you are buying an item, and such an item has been advertised, and the nature of such an item has been said, the buying of the good must go a long way with what you have been described for. So it is indeed a provision. If the buying or if what you are buying does not correspond with the description, that is why we call it breach of contract. That's why we call it breach of contract. The fourth one is bulk must correspond with samples. Bulk must correspond with samples. This implies that where goods are sold by sample, the bulk of the good must be as same as the sample in quality, and the buyer must have opportunity of comparing the bulk with the sample. Whenever you are buying something through sampling method, you as a buyer, you have a right to compare the sample with what you are buying. There are so many cases that are happening in our market today, whereby people do buy through sampling method. So whenever you are buying good through sampling method, the bulk buying must go a long way with that of the sample. The fifth one is merchantable quality good. Merchantable quality good. The goods sold are to be of merchantable quality. What we are actually saying here is that good that the seller intends to sell to the buyer must be of high quality. Good that the seller intends to sell to the buyer must be of high quality. Any breach, whenever a seller is selling a substandard goods, there is a breach under the what we call it contract of sale, and the buyer has a right to sue the seller. The sixth one is fitness for purpose. The sixth one is fitness for purpose. That where the buyer expressly or by implications make known to the seller the particular purpose for which the goods are required, the good must reasonably be fit for such purpose. In this case, whenever the buyer made it known to the seller that I want to buy this good for this very particular purpose, it means that what the buyer is buying must fit the purpose in which he is buying such an article. Whatever you are buying in the market, make it known to the seller that I am buying this thing for this very particular reason, and what you are buying must satisfy you. What you are actually buying must go a long way with why you are buying such an article. Now, in the case of Godley versus Ferry, 1960, a 6-year-old boy bought a toy plastic catapult, broke while being used, and the boy lost an eye. It means in this case, the boy bought such an article for a particular purpose, but it's ended spoiling the boy's eye. It's ended spoiling the boy's eye. In this very particular case, the boy has a right to sue the seller because he did not buy such a product in order to spoil his eyes. He sued the storekeeper and was successful. The boy finally sued the storekeeper and was successful, and it was held that the storekeeper was liable for that very particular reason. Now, the seventh one is delivery and acceptance. Delivery and acceptance. It is the duty of the seller to deliver the good and of the buyer to accept and pay in accordance with the terms of agreement. At times, learners and viewers at home, when we buy goods in the market, there is an agreement that normally reached between the buyer and the seller, whereby two of you agree that the seller will deliver the goods in your own destination. Now, it is the duty of the seller to deliver such good. And you as a buyer, when such good are being delivered, based on the agreed price, you have to pay for it. So these are the provisions of Sales of Goods Act 1893. From our lesson so far, the following points were discussed. Sales of goods, sales and agreement to sell. Sales of goods and sales and agreement to sell. We also talk about the time of sales. We also talk about the times of sale, and we also talk about the provision of the Sales of Goods Act 1893. Learners, before I step down, I would like to give you an assignment that will keep you busy at home. 1. What is contract of sale as specified by the Sales of Goods Act of 1893? What is contract of sale as specified by the Sales of Goods Act 1893? Number 2, list 4 types of sales of goods and briefly explains any 2. List 4 types of sales of goods and briefly explains any 2. Number 3, list any 5 provisions of the Sales of Goods Act of 1893 and explain any 3. List any 5 provisions of the Sales of Goods Act of 1893 and briefly explain any 3. References. In case you want to read on this very particular topic and subsequent topic, you can contact these very following textbooks. Essential Commands for Senior Secondary School by O.A. Ewena. 2. Comprehensive Commands for Senior Secondary School by U.A. Jensen. For in case you want to send your assignments or for any inquiries, you can contact me through this phone number 08065694134. 08065694134. I still remain your Commands teacher, Yari Zakaria. Stay home, stay safe. Keep learning. COVID-19 is real.